Salvage Convention. A. 1910 Brussels Convention, foundation of modern salvage law. The 1910 Brussels Convention was the first international treaty to systematically codify the rules of marine salvage, aiming to unify the disparate practices among nations. It introduced the principle that salvors, those who assist ships in peril, should only be rewarded if their efforts result in a successful rescue. This treaty helped establish a legal foundation for resolving disputes and determining compensation in salvage operations. However, it was largely centered around property salvage, such as saving the ship and cargo, and did not consider the environmental consequences of maritime accidents. B. 1967 Protocol. To adapt the 1910 Convention to changing maritime conditions, a protocol was introduced in Brussels in 1967. However, this update still failed to address major concerns arising from marine pollution and environmental degradation caused by salvage-related incidents. It was increasingly clear that salvors needed more than just a property-based reward system, especially when their actions helped prevent ecological disasters. C. 1989 International Convention on Salvage, Salvage Convention. Adopted by the IMO, the 1989 Salvage Convention replaced the outdated 1910 framework. It modernized salvage law to reflect a growing awareness of marine environmental protection. This convention recognized that salvors often incur substantial costs to prevent oil spills or other environmental hazards, even when these efforts don't result in salvaging the ship or cargo. By providing new incentives, such as special compensation, the 1989 convention promoted more proactive salvage efforts. Key principles of the 1910 convention. 1. No cure, no pay principle. This core concept meant that salvors were only compensated if their operation was successful, i.e., they managed to rescue the ship, cargo, or both. While this encouraged efficient and goal-oriented efforts, it discouraged risky or costly operations that might not yield direct salvage results, even if they could prevent environmental disasters like oil spills. 2. Maritime lien. Under the convention, salvors are granted a legal right or claim, known as a maritime lien, over the salvaged vessel, cargo, or freight. This lien acts as a form of security, allowing salvors to pursue payment even if the shipowner is unwilling or unable to pay. This legal right ensures that salvors have a mechanism to enforce their claims. 3. Judicial oversight. Courts were empowered to review and intervene in salvage agreements. If a salvage contract was deemed unfair, entered into under duress, or overly favorable to one party, a judge could revise or annul it. This provision was intended to protect vulnerable parties, such as shipowners in distress, from exploitation during emergencies. 3. Main innovations of the 1989 Salvage Convention. A. Special compensation. Article 14. This was a groundbreaking provision. It acknowledged that a salvor might fail to save the ship or cargo but still perform valuable work by preventing pollution. Under Article 14, such a salvor can be reimbursed for their out-of-pocket expenses and may receive a bonus, up to 30 to 100% of those expenses, if their efforts significantly reduced environmental damage. However, negligence by the salvor could lead to the reduction or denial of this special compensation. B. Enhanced Salvage Awards. Article 13. Salvage awards under this convention are not fixed, but instead evaluated based on multiple factors. The value of the property saved, the danger to which the salvor was exposed, the efficiency, time, and effort involved, the salvor's success in protecting the environment. This holistic approach ensures fair compensation that reflects both the economic and ecological value of the salvor's actions. C. Expanded definition of salvage. The 1989 convention widened the concept of salvage to include any activity aimed at helping a ship, cargo, or freight in danger, regardless of location or cause. This means salvage operations are no longer restricted to just towing or refloating a stranded ship. They may also involve firefighting, pollution prevention, or emergency cargo removal. 4. Duties and responsibilities. A. Salvors' duties. Salvors now have a dual duty: to save life and property and to prevent environmental harm. They are legally expected to take all reasonable steps to avoid pollution, contain hazardous materials, and coordinate with relevant authorities and stakeholders. This shift marks a move from strictly commercial interests to public interest obligations. B. Shipmasters' duties. Masters of ships are required to assist any person in distress at sea, provided it's feasible and safe. They also hold the authority to enter into salvage agreements on behalf of the shipowner or cargo interests. This ensures rapid decision-making during emergencies without bureaucratic delay. 5. Contractual and legal framework. 1. Binding nature of salvage contracts. Salvage agreements are presumed legally binding, encouraging formal arrangements between shipowners and salvors. However, contracts can be challenged if they were made under unfair terms or pressure, such as in emergencies where owners had little bargaining power. 2. Jurisdiction and dispute resolution. The convention allows for legal disputes to be settled either through arbitration or by national courts deemed competent to handle maritime claims. This ensures flexibility and speed in resolving conflicts related to salvage. 3. Limitation of liability. While salvors are expected to act responsibly, the convention limits their liability unless gross negligence or misconduct is proven. This provision encourages salvors to take action without fear of being sued, while still holding them accountable for reckless behavior. 6. Environmental protection provisions. 1. Damage to the environment. The convention defines environmental damage broadly to include any significant physical harm to human health, marine life, or coastal ecosystems, resulting from pollution, contamination, explosions, etc. This legal definition expands the scope of salvage rewards and responsibilities beyond economic losses. 2. Focus on preventative action. Unlike the 1910 convention, which focused on property recovery, the 1989 version encourages salvors to undertake operations even when success is unlikely by compensating them for risk-taking aimed at pollution control. This shift aims to reduce environmental disasters by rewarding salvors for taking initiative. 3. Public authorities' role. Governments and coastal states are encouraged to maintain response mechanisms, such as oil spill containment and pollution control resources. Salvage operations are expected to coordinate with these authorities to ensure a unified and effective response. Broader impact and legacy. Response to marine disasters. Major oil spills like those from the Immoco Cadiz, 1978, and Torrey Canyon, 1967, revealed the inadequacies of the old laws. These incidents highlighted how salvors often risked everything to prevent pollution but received no compensation if the vessel was lost, leading to calls for reform. The Montreal Compromise. This political agreement, which shaped the 1989 convention, introduced the idea of a safety net for salvors. It aimed to ensure they would at least recover costs, and potentially more, if they acted to prevent pollution, even if the salvage was unsuccessful. Superseding the 1910 convention. The 1989 convention is now the globally accepted standard for salvage law. It balances the interests of salvors, shipowners, environmental protection, and public safety, and is widely ratified and incorporated into national maritime laws. Thank you for watching the video. For more marine topics, please subscribe the channel. Please help us with your valuable feedback to improve the contents.